Okay, this is Western Michigan University Political Science Class 3250, Criminal Justice Policy. And this is distance learning number 3. Looking at your syllabus, that would be the March 16th, 2020 date, where we're going to talk about grand juries, arraignment, pleas, as well as plea bargaining. We'll pick up where we left off after the distance learning number 2 finished. So we want to turn to the issue of grand juries. It's important to understand grand juries come from the Fifth Amendment, where it says specifically that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. One of the easiest ways to think about a grand jury is it's a trial before the trial. That is, a grand jury is a group of citizens who are fair and impartial, who listen to evidence presented by the government, and those jurors decide whether or not an individual should be charged. It is necessary for all federal crimes. Most states don't have a grand jury. Most states leave it up to the prosecuting attorney to make the decision as to whether or not someone should be charged. But in the federal jurisdiction and those states that do use a grand jury, despite whatever the prosecutor may think, a grand jury has to give its approval that someone should be charged. So I'm going to give you a broad outline of at least the process from a crime all the way through the charge, so you can get a general idea of when the grand jury process goes into play. And then we'll talk specifically about grand juries, arraignments, and pleas. So I've done a little chart for you. Let's take a look at the chart so you can get an idea of what we're talking about in terms of the time frame. As you can see here, this is when a crime occurs. There's some investigation that occurs on the part of the police. And then depending on whether it's a federal or, we'll use Michigan as an example, a state crime, it will either go the route of a grand jury or go a separate route. So let's take the federal route first. Criminal event occurs, there's an investigation done by police, and the prosecuting official, known as the U.S. attorney, will take the investigation and give it to a grand jury who will then ultimately decide in what is known as an indictment whether or not somebody should be charged with a crime or crimes. So criminal event, investigation, U.S. attorney gives the information to a grand jury, and the grand jury does what is known as indict the person. Once the person is indicted, then there is an arraignment where the individual is brought before a court. He's informed of the charge or charges, and it's at that point in time, as you can see here all the way off to the side, that the Sixth Amendment rights that we've been talking about kick in. That is, the right to the assistance of an attorney for their defense, to have the right to a public and speedy trial, fair and impartial trial of fact, all of those things we talked about with the Sixth Amendment. They begin at the moment the person's been charged, and their charged is the equivalent of their arraignment. If we go the state court route, again, a criminal event occurs, investigation by the law enforcement agency, and in Michigan, what happens is the case is given to what is known as the prosecuting attorney. Some states, they call it the district attorney. In Michigan, we call him a prosecuting attorney. That prosecuting attorney then decides whether or not a complaint should be filed against an individual. And if, in fact, a complaint is filed, then they're brought before a court for an arraignment. Similar in the federal system, that is, when the person is formally charged with a crime. And as you proceed along this line, and we'll talk about it once we get to the issue of a trial, it's strikingly similar. That is, the federal system and the state system are similar. The key, though, is to understand this idea of a grand jury and their role in the whole process. So keep that in mind in terms of the process, in terms of a criminal event, and whether it's a federal or state type of crime, what happens. So in talking about a grand jury, we need to know a couple of basics. Again, as I mentioned, it's kind of like a trial before a trial. Some of the things that a grand jury is required to do is to listen to the evidence, review that which the government is providing, and then decide whether or not there's probable cause to believe that a crime or crimes have occurred. If there is probable cause to believe that crimes have occurred, then they indict the person. That is, the person is formally charged with a crime. Some particulars about a grand jury: it is a group of citizens who are brought into court, if you will, in a secret room where the government presents the evidence. A majority of the grand jurors have to agree that there's probable cause. The grand jurors get to ask questions of the witnesses to come to the decision of whether or not there's probable cause. The defendant doesn't have a right to be there. It's all done as an investigative tool for the government. So in the Western District of Michigan, for example, I think what happens is the federal court requires citizens to be on a grand jury for an extended period of time. They listen to evidence on a variety of cases, and then they ultimately say whether or not there's probable cause so that they can be charged. I don't know if it's a 6-month period of time, but it's an extended period of time where they go to a courthouse or a secluded facility where the prosecutor would present that evidence maybe 1 or 2 times a week. They go up and they make that decision. There may be multiple grand juries convening at any one time, again, because in the federal system, you need to make sure that every person goes through the grand jury process before they are charged with a crime. So this comes out of the Fifth Amendment. Again, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Couple other particulars about the grand jury process. As I mentioned, the citizens are selected randomly from the community to come in and sit as a grand juror. There's a determination whether or not they can be fair and impartial. The prosecutor gets to present their evidence. The jurors can ask questions of the witnesses. They can also ask questions of the prosecutor. Witnesses still have Fifth Amendment rights. That is, again, as we talked about previously, that if a witness may say something that is self-incriminating and they're being compelled to do so, and it's the disclosure of evidence, the Fifth Amendment kicks in, so witnesses may assert their Fifth Amendment right. Again, the defendant is not necessarily permitted to be there. They can be there if the prosecutor allows them to be there or wants to ask them questions, but more often than not, the defendant is not present. One interesting thing about grand juries is that they're required to be conducted in secret. Unlike with a regular trial where it has to be done out in the public, in open, grand jurors meet and decide on whether or not somebody is charged in secret. And we should understand the rationale behind that. There's a couple of reasons why we have this mechanism that is done in secret. First of all, we don't want to have those that are being considered for criminal charges to know necessarily that a grand jury is thinking about whether or not they should be charged, because if they were aware of that, they may then choose to flee the jurisdiction. So one reason why these things are done in secret is that it limits the escape of those who an indictment may be contemplated. It's a different procedure than an actual trial. It's an investigative stage. So obviously we want to make sure that if in fact somebody is not indicted or not charged with the crime, then their reputation is held intact. That is, if you have the grand jury process kept secretly and no indictment occurs, then the person's reputation can generally remain intact. It ensures the freedom of the grand jurors to deliberate and prohibits them from being infected from outside sources. If you were a member of a grand jury and everybody in the community knew that you were a grand juror, then you might possibly feel the weight of some pressure from outside from in the community. So because they don't know that you're a grand juror and because the process is done in secret, it helps ensure the freedom of the grand jurors to do their deliberations and make their decision without any type of recourse. If there's a compelling reason to do so, then a grand jury secrecy may be broken. That's obviously made by a judge, but most often the grand jurors are deliberating in secret. Usually it just takes a majority of grand jurors to pass on an indictment, that is, to indict somebody. So if you have 25 grand jurors and 13 of them agree, then you may have sufficient evidence such that the person can be charged. If there are 25 and 13 say there's not probable cause, then the person is not charged, because you do need a majority. And again, the threshold is probable cause of a criminal act. In those communities, like the state of Michigan, where a grand jury is not used, you bypass this process. That is, you don't have to bring in jurors to make a decision. The decision solely rests with the prosecuting official. And as I mentioned, in the state of Michigan, that person is known as the prosecuting attorney. Some jurisdictions, it's called the district attorney. That particular agency receives law enforcement materials and then decides if there is probable cause that a crime was committed, and if so, then the person can be charged. Obviously, an individual state prosecutor can use whatever threshold that they would want to have to charge somebody with a crime. At a minimum, they need to have probable cause that a crime was committed. In Kalamazoo, it is oftentimes believed that the prosecutor's standard for charging somebody is there's a reasonable probability of conviction. Because if all you have is probable cause at the time you charge somebody with a crime, and it's not likely to get better before trial, as we talked about what the standard is at trial, that being beyond a reasonable doubt, the prosecutor is going to lose. So although it only takes probable cause to charge, more often than not, prosecuting officials would like to have much more than that in order to begin this process. The first stage after the grand jury issues the indictment or the prosecutor decides to charge is, as I mentioned, that arraignment. And as we look here in the chart here, the arraignment process, the bold line, that's where the person is charged. The Sixth Amendment kicks in, and all the rights that we talked about go ahead. What happens at an arraignment is a process where the court informs the individual they've been charged with a crime, informs the individual of all of their rights, including the right to a lawyer, to a trial, and all of those things. If they needed a court-appointed or a public defender, the court would talk to them about that. So an arraignment is that first formal stage, and oftentimes it is a quick proceeding. An individual may choose to enter a not guilty plea. On some cases, an individual may choose to plead guilty, and we'll talk about that in a second. But the arraignment is that formal beginning of the criminal process as it relates to the Sixth Amendment. If the matter is not resolved, as is the case with most of them at an arraignment, bail has to be set to continue until the next court hearing. And so we're going to talk about those things that stem from an arraignment. That is, pleas. Ultimately, we'll talk about bail, and we'll also talk about this concept of plea bargaining. So what are the available types of pleas that an individual who's charged with a criminal act can enter? There are a few of those, and I'm going to turn the tape off for a second and then reconvene with my board here and talk about the various pleas.